first thing, the big news right now is a lot of people are talking about public charge. I want to make sure people really understand what this means. There's been a lot of misinformation in the press around public charge. What public charge really refers to is people being admitted to the United States, and they cannot be admitted if they're determined to be public charge. And you're really, when you're talking about admission, in our context, we're mostly talking about people who are seeking green cards through a family-based petition. Now, there are other ways that public charge does come into play, for example, for non-immigrant visas. But mostly we're worried about people seeking family-based petitions. Right now, and since the end of the Clinton administration, a public charge has been defined as someone who's likely become primarily dependent on the government for subsistence. And they're really mostly looking at two issues. One, they're looking at public cash assistance for income maintenance. And with that, you're talking about things like supplemental security income or temporary assistance for needy families. The other issue is with institutionalization for long-term care at government expense. And here we're talking about Medicaid. If you don't fall into either of those categories, you're not considered a public charge. So for existence, things like SNAP, regular Medicaid, all these kind of assistance do not apply, are not considered, I should say, for the public charge issue. What they're proposing to change it to, or what they will propose, I should say, is that they're going to look at any time anyone is receiving benefits, what we call means-tested benefits, so benefits where eligibility is determined by income. And they're not going to just be looking at the individual seeking admission. They're going to take a broader view and look at family members. So let's say you have someone who's trying to get their green card, but they have a U.S. citizen child who's, for example, receiving benefits through the Children's Health Insurance Program, through CHIP. Well, now that parent would likely be considered to be a public charge. They're also looking at developing standards for deportability. So this is going beyond just admissibility. They're looking for people who've already been admitted, who've already gotten their green cards. There is a provision in the law to allow for their deportation if they are a public charge within 5 years due to no fault of, except for due to no fault of their own. So an example of someone who would be excluded from that would be someone who, let's say they came here, got their green card, were working, but then their employer went bankrupt and they lost their job. Well, that would not be considered for the deportability issue. The big thing for people to understand here is the timeline. So we are still waiting for the proposed rule to be published. We have heard that this could happen any day now, but we've also been hearing that this could happen any day now frankly, since April. So we're kind of just sitting here waiting. When that proposed rule is published, that will trigger a public comment period that will last 60 days. And so that gives all of us, everyone on this webinar, an opportunity to let the government know basically what we think of this. Once they get all of that, they're going to have to analyze all those comments and respond to certain issues that are brought up in those comments, and then they'll publish the final rule. Now, the current draft, the most recent draft that we've seen of this final rule would create a 60-day grace period. That is, benefits that are received during those 60 days would not impact a public charge determination. So people have a little bit of time to disenroll from any programs that might be happening. So our position at this point is for folks not to be disenrolling now. Let's wait to see what's in the proposed rule. We expect there will be a grace period in there. So folks should not be disenrolling now. I also want to make sure, because this is something that's been misreported by the media, this does not impact citizenship applications. Public charge is only used when you're requesting, when you're applying to be admitted to the United States. So this would not be impacting people who are going from their green card to citizenship. The next thing I want to talk about briefly is, and frankly, these are all kind of interconnected, is something called the RFE, or the Request for Evidence. At the beginning of July, USCIS issued some new policies that basically changes how they're going to deal with requests for evidence. Now, traditionally, anytime someone has an application in, and USCIS, in adjudicating the application, says, "Oh, we need a little more for this," they would send what's this RFE, this request for evidence, and say, "Hey, we need specific things to be able to accurately adjudicate this this application." Well, now what they're saying is that the officers will be allowed to reject applications outright rather than issuing a request for evidence. So a lot of these cases where we would normally see requests for evidence, we're just going to see these applications being rejected from now on. Tied into both that and the public charge issue is a change in the notice to appear. This again was a change that happened in the beginning of July. And what happened here is that now USCIS used to have guidance on the notice to appear, which was basically saying, let me take a step back. A notice to appear is what triggers immigration court proceedings. So this is what places someone in immigration court. This is most often used by ICE, but USCIS has traditionally used it in cases where an applicant committed fraud in the application itself, or where there's a serious threat to public safety by the applicant. Those were the only times they would issue a notice to appear. What they've changed their policy now is that they are going to issue a notice to appear anytime someone is inadmissible. So again, the public charge issue will come up here. Anyone who is deportable, or anytime the denial of an application leaves the applicant without status. So not only are we going to see a lot more applications denied because of the public charge and the request for evidence issue, but we're going to see a lot of those cases having notices to appear being issued in them. And lastly, and Denzel talked about this, but I'd like to give people a little more of an overview of what we heard yesterday, which is that they are capping refugee admissions at only 30,000 for fiscal year 2019, which starts October 1st. Here you've got a chart just showing what the cap has been and what actual admissions have been over the past few years. You can see for fiscal years 13 through 16, we were actually pretty much hitting the cap in those years. Fiscal year 17, we actually exceeded the cap because that was originally set at 110,000 by the Obama administration, and then lowered to what you see here is 50,000 by the Trump administration when they came into office. So we were able to exceed that cap a little. But like Denzel said, it's set at 45,000 this year, and we're only getting about 20,000. Right now, the fiscal year isn't over yet, so we are expecting a few more people, but right now it's actually just below 20,000 admissions through the end of August. And of course, we're going to lower that cap down to 30 for fiscal year 19. I would expect to see similar numbers, similar percentages, at least in terms of actual admissions. Part of the problem we're seeing just kind of generally is that the administration is taking a lot more time to process applications. And just as another example of that, there are now over 750,000 naturalization applications pending, which is actually a 44% increase over from a year and a half ago. So that's all I wanted to present to folks. I can take a couple of minutes of question and answer, though.
Thank you so much for that, Sarang. And I want to make a really important point. A lot of these requests for evidence, a lot of the delays that we are seeing will cause many people to fall out of status. Is that correct?
Yes, that is correct. Absolutely. And it makes it a lot more risky for people to be submitting applications. So we might see a drop in total application numbers to begin with.
And we have a couple of questions because people are very concerned about all this public charge and the new criteria. The new criteria will not be retroactive. Is that correct?
That's what our expectation is from seeing drafts of the policy. But until we see what they actually publish in the Federal Register, we're not going to know for certain.
You are telling people as of right now, stay on whatever programs that you're on. You're entitled to those things. Stay on them until such time.
Yes, absolutely. As long as they're actually eligible for those programs, they should certainly be staying on them right now.
And a lot of questions about, we have a lot of teachers and educators and guidance counselors. Free lunch, reduced lunch. I mean, those things for students, are those part of the equation?
Well, again, we won't know until the final proposed rule is published. What we do know is that in an earlier draft, they had included those, but not in a later draft that we saw.
When we look at food stamps and people in need of medical aid, what do you therefore do in these kinds of situations? And what would you advise going forward for the families who are left without a breadwinner, who are still here, who have children to raise? What services, I mean, what can they possibly request or stay on?
You know, it's unfortunately very difficult. As long as the kids can stay on whatever they would normally be eligible for, whether their parents are here or not. But obviously, if you're a child, how do you apply for those services on your own? A lot of these kids get put into foster care, or they get left with other family members, and maybe those other family members are themselves undocumented. And so how are they going, you know, they've just seen another family member being deported. So now it makes them much more nervous about going to any kind of government agency to try and get services. And
Blanca, are we seeing, I know your research is pretty limited to what you just presented, but are you or Sarang seeing other trends in terms of detention? You know, they're going after just a lot of the low-hanging fruit, the people who are going about their daily lives, the people who are not criminals, who are going to court and going to work. Is that the trend now, going after the low-hanging fruit?
Yeah, we're certainly seeing a drop in the percentage of those detained who have any kind of criminal conviction. We're seeing people, Blanca mentioned the fact that the old administration had priorities, and people who didn't fit these priorities, I wouldn't say they were okay, but they weren't enforcing the law against them. Well, now we're seeing them go after those people because they have them, you know, they know where they are. Sometimes they have to check in with ICE.
Mm-hmm. And yeah, here in LA, we've also seen a number of people get detained when they go in for their check-ins as well. So I just wanted to reiterate that.
And as you pointed out, Blanca, it's and Sarang as well. You know, it's people who have 20-year-old charges against them, who are back on the payroll in terms of who's being targeted. Correct?
Yes, and these are long-term residents with many years in the United States with extended ties to communities, having, like I said, children in the United States. So they have extensive ties in the U.S.
And Sarang, before we go, can you give us a little bit of an update on what's going on with Dreamers and DACA?
It's still kind of up in the air. It's working its way through the courts. We've seen a number of federal district courts issue an injunction preventing the administration from ending the program. We had a surprise decision last month, or maybe it was earlier this month, come out of Texas. Judge Hanen, who Texas and a number of other states had sued to end the program. And Judge Hanen right now has refused to do that. So I think we're really waiting to see this work its way up through circuit courts and then to the Supreme Court.